Hi, I'm Tom Spiegel with the Spiegel Law Firm, where we help people who have been wrongfully fired or afraid that they might be. Today, I want to talk to you about long-haul COVID symptoms and protection for those under the Americans with Disabilities Act. As you may have heard, there are some people who get COVID, and the effects of that disease can last for a long time, right? They can go on for months. Sometimes, there are some people that are still suffering a year or more later after they've been infected, and the medical community is calling those long-haul COVID cases. There can be a host of symptoms associated with this affliction. You can have headaches, you can be dizzy, you can have fatigue, muscle soreness. There's a whole list of ailments that people suffer from when they have long-haul COVID. So the question is, for the purpose of this video, what are the legal protections for somebody that has these symptoms at work? And the answer is that in many instances, you're going to be covered under the Americans with Disabilities Act, which is a federal law designed to protect people with disabilities. The definition of disability under the Americans with Disabilities Act is very broad. It includes anything that interferes with a major life function or some kind of bodily symptom. So your digestive system, your nervous system, your circuit, you name it. One of those systems, anything that is impacting that can be considered a disability under the Act. There's a whole list of things that are covered, that are considered a disability. If you look at the regulations, if you go to the EEOC's website, that's eeoc.gov, you can get a lot of information about the ADA. But so for most people who have long-haul symptoms, they are considered disabled, even if they later recover from those symptoms, under the ADA. What does that mean at work? It means that it's illegal to discriminate against you because you have this disability. So if you get long-haul COVID, let's say you're having dizzy spells, it otherwise does not affect your work. You're getting your work done, but your manager decides that they want to fire you because you're dizzy, right? Because you're kind of wobbling around, and they think you're a liability. That would be a legal discrimination under the Americans with Disabilities Act. The second big piece of it is that those with disabilities under the ADA can be entitled to what we call an accommodation in the workplace. That basically means some kind of change in your work environment. So for instance, if let's say you have long-haul COVID and you get really bad headaches, it's better if you're in an office where the lights are dimmed. You can ask your employer, hey, can I get moved to an office where I can dim the lights, or the lights are not as bright as in this office or wherever it is I happen to be sitting. That is a request for an accommodation under the ADA. And under that law, your employer is required to engage in a good faith dialogue with you. That doesn't mean they have to give you exactly what they asked for, but it means they have to try. It means they have to see if they can somehow accommodate your disability in the workplace. An example of an office with with dim lighting, that's probably a pretty easy one. But there are all kinds of accommodations. It can include time off of work. It could include a transfer. It could include limited working hours. All those could be a reasonable accommodation, but regardless, once you raise the issue, your employer has to discuss it with you. They can't, out of hand and comply with the law, say, no, we're not going to do that. Now, if it's a substantial burden, on the employer, then they could be within their legal rights to deny you the accommodation. If you need, let's say, for example, you need a lot of time off of work. You need 3 months off of work. Well, most courts are going to find that's not a reasonable accommodation. Like, you have to be able to fulfill your job. You have to be able to do what is required of you in your position. And if you're not showing up for 3 months, that's not meeting those obligations. So there are some circumstances where courts are going to say that request that you're making is not reasonable. But the short of it is, if you are suffering from some of these symptoms, long-haul COVID, be aware that you do have these protections, and if you need to, you can avail yourself of them. You can always talk to an attorney to see if what you're experiencing at work is potentially a violation of the ADA, and what steps you could take to remedy that if that's happening to you.